Another great episode here on the Professional Edge. My name's Sean Todd, tax attorney, CPA, and certified financial planner. We're talking about estate planning do's and don'ts. Don't have an invalid will because the law of descent and distribution is going to control who receives your property, when, and in what amount. Don't add your kids to your bank account. The reason being you expose that account to the claims of your kids' creditors. So that's another don't. The other don't is don't leave your life insurance policy outright to your surviving spouse. Reason being you want to make sure and guarantee that those remaining proceeds are going to go to your kids. So how do we do that? Well, we establish a trust within either our last will and testament or within our revocable living trust. And in that we say proceeds shall be paid to the estate of decedent, and therefore the provisions of your estate planning document captures those proceeds, and it says, hey, we're going to hold these here. We're going to allow access to the surviving spouse. But when the surviving spouse passes away, these are going to go to the kids in equal shares. Because we are all living longer now, and there is an expectation that that surviving spouse is going to get remarried during their life. Yeah, some don't, but majority do. And when they do, and they execute this I love you will, and it says, I love my new husband and I love my new bride, well, lo and behold, if that's the case, then whatever is remaining of those life insurance proceeds is going to go to that new husband or new bride. So if that's not what you want to have happen, or even the chance of that happening, then what you would want to do is have a testamentary trust established within your estate planning documents. Allow those life insurance proceeds to go into that testamentary trust, dole out for the surviving spouse as long as they need it, but you guarantee that your kids are going to receive those remaining proceeds. That's the only way you can do it. So again, it's a wake-up call for listeners here on the Professional Edge. Your beneficiary designation on your life insurance is surviving spouse first, kids second. There is no guarantee that those kids are going to receive any of those proceeds. So if you want to change that and you want to guarantee that the kids will receive the remaining proceeds, you have got to give our office a call at 877-654-9798. That number again, 877-654-9798. So on to what is known as probably the largest financial asset of all our listeners here on the Professional Edge is your retirement account. That it could be your 401k or your 403b, depending on who your employer is. That could be a 7-figure account, $1 million plus account. And guess what? That designation or that asset is controlled by a simple one-page document. Staggering. Now, that one-page document is known as your beneficiary designation. Well, when you signed up for your 401k and you're married, you got 2 kids, well, you probably put on their primary beneficiary as my spouse, contingent beneficiary, you name your kids, and that's it. You put it away. You have not changed it, looked at it, updated it, and now it's grown into a $1 million account. So that beneficiary designation, again, supersedes whatever you have in your estate planning document. Now let's think about this. Let's roll this forward. You have $1 million account. You're the husband. You've been working hard, and primary beneficiary is your spouse. That way you stay happily married, and they double check that. And an unfortunate event happens and you pass away. Boom. Then that 401k is going to go to your surviving spouse. They're probably going to do a spousal rollover on that, and now it is in their self-directed IRA account. And a few years goes by, let's say 5 years, the memory of you has passed, and now that spouse gets remarried. And they head on down to the 1-800 financial firm and they say, okay, great. Who do you want to name as your primary beneficiary? And they look at each other and they say, well, what do people normally do? Married couples. Well, they normally name their spouse as being the primary beneficiary and then name their kids as contingent beneficiary. And is that what you want to do? When they look at each other and say, yeah, that's what most people do, so we're going to be like most people and do that. Well, lo and behold, the surviving spouse of the first passing passes away. Now, guess what? That new husband or new wife gets to receive what you worked for on your 401k, that $1 million account. Well, that new spouse has zero legal responsibility to leave any of that to your children of the first marriage. That's troubling, in my opinion, because yes, you want your surviving spouse to have access to this, but I'm not sure you want that new husband or new bride to receive the balance of your hard work for 30 plus years in accumulating that 401k balance. So how can you guarantee that these proceeds are going to go to your children even if your surviving spouse passes away? Well, at Estate Management Counselors and then via my law firm, we create what is known as a designated beneficiary trust. This is an estate planning due. So with that, we name the designated beneficiary trust as being the primary beneficiary on that qualified account, because the beneficiary designation on that qualified account supersedes whatever you have in your estate planning documents. So now we name a designated beneficiary trust as the primary beneficiary on that account. Once that is designated, when you pass away, then the custodian of that 401k is going to go, okay, we need to pay this to a designated beneficiary trust. That then holds it for the surviving spouse, doles it out, any required minimum distributions get paid out. If there's the right evidence put forth to the trustee of that designated beneficiary trust, we can take out more than the required minimum distribution. Yes, we are controlling it from the grave, but it's the only way we can guarantee the balance of that account after the surviving spouse passes away goes to our kids however we deem that we want it to be. So that could be 50-50, equally split to the kids, or 60-40, however you want, but it guarantees that your kids will receive the balance of that 401k account after your spouse passes away, the surviving spouse passes away. Even if they get remarried, they cannot update this beneficiary to that new spouse. Yes, that's significant. That is an estate planning due. Let's try and protect this family unit that sacrificed to accumulate these funds of the $1 million in that 401k account. Yes, we all had to sacrifice in order to make these contributions and not blow them. So why would we want the chance of these proceeds being given to that new spouse in a later on marriage? Let's avoid that entire situation. Update what is normally the largest financial asset in a married couple's estate is the 401k. Let's take it out of the hands of two little lines on a beneficiary designation form. We're controlling $1 million asset by a simple one-line item on the beneficiary. That's ridiculous, in my opinion. So therefore, we're going to take that document and we're going to say we name the beneficiary, the primary beneficiary, as the designated beneficiary trust of Bill Smith. When Bill Smith passes away, that $1 million 401k drops into the designated beneficiary trust. The surviving spouse is going to be protected, but If that surviving spouse gets remarried, wants to change the beneficiary designation because there's a fallout between mom and daughter, she's going to disinherit her. Well, you know what? She can't be disinherited because now this designated beneficiary trust, the surviving spouse has no ability to update or change or to eliminate, to disinherit any of the children. So you plan this out and you agree that a surviving spouse shall have access to it, but the remaining balance shall go to our kids in equal shares, period. It's guaranteed. This is the only way that you can guarantee that your 401k is going to be equally split among your kids. Because again, people are living longer. They're getting married later in life. Let's say they get married at 65. You pass away at 62. The $1 million 401k goes to your surviving spouse. They get remarried and they update the beneficiary designation at that 1-800 financial firm. And it says spouse, primary, contingent, children. Because you can do a spousal rollover and not have any tax implications whatsoever. Well, that sounds good if you're not that sophisticated in your financial and estate planning. Okay, we're going to do that. Well, you just guaranteed that your kids are going to be disinherited. Yeah, money changes people. We've seen it all the time. The new spouse rolls that over to a self-directed IRA, and if they have kids, guess what? Their kids are the primary beneficiary on that account. I've seen it. I shake my head at it, and it does happen. The kids of the couple who have earned this money get disinherited of the largest financial asset, and there is nothing that I can do once the cat's out of the bag. So again, if this is of importance to you as a listener here on the Professional Edge, you think about it. Have your primary beneficiary as your spouse, contingent beneficiary as your kids. If you want to guarantee that your kids are not going to be disinherited, then you should give our office a call at 877-654-9798. That number again, 877-654-9798, to make sure that you have a designated beneficiary trust as being the primary beneficiary on your qualified account. And this applies to Roth IRAs as well. It's not just with regard to your 401k or your rollover IRA. This is Roth accounts as well, because the smart people, some have done Roth conversions, or some, as soon as the Roth was available, they've contributed, and now it's a couple $100,000. If you don't want to disinherit your kids on a tax-free account as well, then you would need the designated beneficiary trust to being the primary beneficiary. So I appreciate your time and listening to the estate planning do's and don'ts. I am tax attorney, CPA, certified financial planner, host here on the Professional Edge, and I hope you've given you some food for thought and the impetus to say, you know what, I probably need to have a conversation to make sure that my estate plan is on the do side and not on the don'ts. So to start that conversation, do give our office a call at 877-654-9798. That number again, 877-654-9798. And yes, I hope you can understand the passion within my voice on getting these things taken care of, because we all know we're not going to get out of this alive. And make sure your things are taken care of and your kids are properly planned for, and your surviving spouse. Again, thanks for listening to Professional Edge.
With today's financial markets, are you getting the personal and professional attention you and your money deserve? Clients of estate management counselors benefit from having one set of professionals advise them on their tax, estate planning, and investment advice. We call that the Professional Edge. Sean Todd is a tax attorney, CPA, and certified financial planner. With over 15 years' experience, he welcomes the opportunity to assist you in preparing for retirement, implement effective tax planning strategies, and to help you properly plan your estate. His radio show, The Professional Edge, is aired weekly on Sundays at 9 a.m. If you're interested in meeting with Sean, call his office at 877-654-9798. That's 877-654-9798. Do you want to feel more confident about making the right investment, tax, and estate planning decisions? Today, these decisions are more complex than ever. Have you thought about working with a professional advisor and not sure who to turn to? Not sure what qualifies one to be an advisor? Scene Todd is more than qualified as a tax attorney, CPA, and certified financial planner. Scene is with Estate Management Counselors. Estate Management Counselors operates as an independent fee-only investment advisory firm. They're dedicated to gaining a personal understanding of their clients' objectives and implementing professional counsel and advice to achieve those objectives. So take a second to talk with Scene Todd to learn how you can benefit from their multidisciplinary practice where they coordinate their clients' legal, tax, and investment strategies into one comprehensive and integrated plan to enhance and protect their clients' financial security. You can reach Estate Management Counselors and speak with Scene Todd by calling 1-877-654-9798. That's 1-877-654-9798.